Speaker, with your permission, I'm going to answer to PQB 194 and PQB 213 at the same time, as they refer to the same subject matter. Madam Speaker, I'm informed by the Financial Services Commission that 4 applications for an investment banking license under Section 79A of the Financial Services Act have been received as at date. Out of the 4 applicants, 2 have already received their licenses. They are namely Affaire Sobrinho Africa Limited on 25th November 2016 and déclaré Investment Advisory Mauritius Limited on 30th December 2016. The 2 remaining applications are still in process. Both licensees are domestic companies, and therefore details about the owners, shareholders, and directors are publicly available at the Register of Companies.
Thank you, Madam Speaker. Madam Speaker, under the Financial Services Act, Section 79A, it is clear that anyone who wants to apply for an investment banking license has to comply with the FSC rules. Now, the Honourable Minister has just informed us that with regard to Affaire Sobrinho, he obtained his license on the 25th of November 2016. Whereas, in fact, the license, the FSC rules, were actually made on the 9th of December and only published on the 24th of December 2016. So has the Honourable Minister considered why is it that Affaire Sobrinho has obtained an investment banking license in breach of the Financial Services Act?
Madam Speaker, I'm informed by the FSC that the rules were ready, but they were gazetted slightly later. But this did not preclude them to consider application.
The rules is dated 9th December. So whoever is giving you this information is misleading you. 9th of December is after November. Okay? According to the rules now, the person who's going to perform investment banking must have at least 5 natural persons and must have a capitalization of at least 50 million rupees. Now, out of publicly available information at the Register of Company, this company has only 3 directors, one of which has just been interdicted, which is very familiar to the Honourable Vice Prime Minister, Mr. Pinto. So there's only 2 directors, and there's only 100 shares, not 50 million rupees. So why is it that even now, this company is not respecting the rules?
Madam Speaker, simply because these companies have been authorized not to operate by the FSC.
I ask the Minister, in view of the various allegations that have been made concerning emails being exchanged between the former Vice President, the State House, and the Director of ASA.
Honourable Uncle, please don't, we are not allowed in this House to drag in the debates either the President or the Vice President or the State House. Please.
No, I'm not bringing the President. I'm not questioning the conduct of the President, Madam Speaker. I wish to seek clarification from you whether in the rules it is mentioned that I cannot ask questions on the State House.
Honourable Member, when you are asking questions on the State House, you are indirectly saying that the President is involved. So be careful as to the way you are putting your question. You can ask the same question, but in a different way.
Officers of the State House, has there been any inquiry that has been initiated at the level of your ministry to find out whether the contents of those emails are true? And if they are true, what does the minister propose to do?
Well, Madam Speaker, as Honourable Member, I also took note of those mails, and I've asked the FSC to look into that matter and report back.
With regards to with De Vere, namely Mr. Nigel Green, may we know when they applied for the license and when they obtained the license? And secondly, if we can know, given that his reputation...
One question,
if you may give me the
Please.
second question after.
Yes, with respect to De Vere, the application was made on the 14th of December 2016, and the license was granted on the 30th of December 2016.
De Vere, is Honourable Minister aware, and you can do it by just going by internet and clicking the name De Vere and Nigel Green, he will know that this De Vere and Nigel Green have had problems with the regulators in South Africa, in Hong Kong, in Japan. So may I know, why is it that this government keeps giving investment banking license to unscrupulous people and not people who will put the reputation, who is putting the reputation of Mauritius at stake?
Yes, Madam Speaker, I'm aware of all these press articles which appeared, and I'm advised by the FSC that they have checked all this information, and these information are not true. They do not relate to the same company. You go and check the name again. The name sounds the same, but they are not the same companies.
I have a simple question to the Minister. In view of what has cropped up in the press, is the Minister personally satisfied that all the procedures have been followed in the case of Affaire Sobrinho, Africa?
Madam Speaker, this case has been surmédiatisé. By looking at the file and obtaining the relevant information, I must say that many articles which were published, be it on Mr. Pinto, be it on the other aspects of the application procedures, they are unfounded. So what we are trying to do by this, we are attacking the reputation of our country, and this is what we are doing, and this is what is actually affecting our reputation. Most of the facts, most of the information which appears in articles are unfounded, and I hope that there is retention at that level so that we become a serious jurisdiction where we are doing business seriously.
In both cases where these promoters have been granted the investment banking license, the Honourable Minister answered that they were domestic companies. Doesn't the Honourable Minister agree that in the case of domestic companies, since they are not GBL companies, there is less oversight, less control over the management of these companies? And is this good for our sector, to allow domestic companies to be granted such a license?
Madam Speaker, the investment banking activities are under the supervision of the FSC. So any company which are conducting these kind of activities will fall under the supervision of the FSC. So I can't see that there will be less control, less supervision. So they will always be subjected to scrutiny, to monitoring by the FSC, as long as they are engaged in these kind of activities.
It is in answer to what the Honourable Minister has said. The Honourable Minister has said that information communicated to him by the FSC is to the effect that De Vere and this Nigel Green are not the same people who has been interdicted. Is the Honourable Minister aware that this same Mr. Nigel Green wrote to the FSC on the 8th of March to try and explain and justify what has been written about it, and in particular trying to say that he's collaborating fully with the South African authorities, where there has been a mega Ponzi scheme involving his company and Belvedere.
Madam Speaker, I will stick to what I've been advised by the FSC, that these two companies, although bearing more or less the same name, they are not the same companies and they are not part of the same group.